pray that this case be adjourned up to the 4th of September for Wednesday. Lord Chairman and honorable members of the court, as my learned colleagues, the prosecutors, know, our client has been confined in custody of the military police at Makinde since the 13th of June 2018. Up to now, on no formal charge, in fact, on no charge at all. This is exactly from that date, 72 days today. Or 1,728 hours or so. Clearly, this is not in conformity with our laws, our constitution, and other laws of this country. My Lord and members, our client was well aware, as we were, of his rights and what to do to ameliorate that injustice. He and we knew the appropriate legal options provided in our laws to ameliorate this unlawful detention, because it's beyond the 48 hours. We all know that. However, my Lord, and members of the tribunal, on his instructions, his own instructions and volition, and after intense consultation with his legal team, we acceded to his wishes. He was prepared to endure the dignity and personal discomfort and suffering, and allow those responsible for his confinement, his accusers presumably, to have a run through their pile of falsehoods, because he knew very well that truth would eventually triumph, but he didn't think it would take so long. My Lord and members, we are grateful that today, at least we have formal charges. And he's been able to answer to these charges. And he and us, assisting him, are going to prepare our defenses. We would like to commend the UPDF authorities generally and the military police headquarters at Makinde in particular for treating our client with respect,
Senior counsel, you can protect the constitution has against court and seeking an adjournment. So what is the response? Because we don't want to go to the details of the study, what is it our group? You agree with the adjournment so that we proceed.
No, I'm applying for bail. I can make in the background. This is a special case.
The bill the user has to do by not submitted. Is it filed in the registry?
Where our client got to know the possibility of this charges this morning. We got to know it last night. We are cognizant of the period he has been in custody. And we know, Honorable members of court and my lord, that this court, this president of this court, the special president, where bail applications verbally have been entertained and appropriate action is taken. We are taking that route. My lord, I specifically refer to the case of the late Major General James Kazini, and the case of Colonel Shaban and Khadija. In both those cases before this one court, the court exercised its discretion and entertained vow of bail application. We don't want, my lord and members of the court, if it is possible, to keep General Kayihura 1 hour more than 1,728 hours is beyond attention. Do you believe that is possible? My lord, I think this point, members, I'm applying for special consideration for this application for bail now. There is no, my lord, there is no prohibition in the law against this court entertaining vow application. And as I said, this court, this precedent, not one case for it. I understand that it is of course discretionary, but I am praying to this court to exercise its discretion in our favor, in the favor of General Kayihura. And I will give reasons.
Also, we can have the same theory regarding law. Thank you, Council, for your submission. The procedure normally here is that you have to write for an application, a motion, which will be submitted, and consideration will be put in place. So can you do that within a short time? Deliver it, that's also a motion, and the application will be considered on the 28th of this month. You write your products of motion with the affidavit, and you present your sureties, Then we listen to your case on the 28th.
Much obliged.
For the application only. But the main case comes in September.
I understand. We understand your issue.
We have already considered it's a situation you have already explained. That's why we have reduced the date of 28. A few days from now, please make it in written. We shall consider it for the good of your client.
Much obliged.
That's right.
My Lord, we are going to do that. It's Monday.
That's
Very well.
any addition? If there's no addition,
Can I try? Hello?
yes.
Just to add to my brother's request, our client has been in the custody of the military police. It is today when we breathe some fresh air when he was charged. There is a weekend. This is your serving officer. He has not had the benefit of freedom to be charged and to face the consequences of his charge. Finally, today's read out. There is a lot of motion requirement which the judge advocate has presented. It's a formal document. But there is precedent in this court, my lord, that in this court, you alone can determine whether a piece of paper or what we have beseeched you should stand between him and a long weekend, to be with his family, to sleep on his bed, stretch his legs, to walk and breathe the air of freedom for once, just between a piece of a document and your decision. And yet you have done it in other cases. With the other cases in the past, you have ignored the document. You have listened to the plea of our client. He deserves to walk out of this court in freedom together with us and to touch his wife and his children and look at them and greet his friends. My Lord,
Please, please, don't interfere. Your work is to listen, not to clap.
my Lord,
Please,
we beseech you.
have a seat.
We beseech you.
Please,
And
counsel.
we beseech court.
You can have a seat. You are repeating the same thing he forwarded.
Yes.
The same thing in a different way.
Yes.
Please, if there is nothing new you are adding to him, let me answer you that. One, in your office, don't you have records?
We do, my Lord.
Yes. We need to keep those records. That's not so motion must be written, but we have records.
And we
Do
do
not babble.
My Lord, we are obliged to your direction. We are only reminding you that in the other cases, you have allowed babble.
No, please, this time, put it in black and white. I've given you a short time. Than appearing on the 4th of September, I've said 28th. Come 28th, be here. With your sureties. And I know the state of your client, that's why I have made that consideration. Please, come on 28th, then we shall hear your prayers properly.
Second, Honorable Chairman, once court has pronounced itself on the matter, cannot again start making, there is a low amount of abolition that will make it advance.
So this case is adjourned to 4 September 2018 for mentoring and 28th August for consideration of the notice of motion. And the general still will be remanded in military police. Thank you.
Pictures there coming in from Makindye Court Martial, military court, if you like. We have seen General Kayihura has been charged formally with 3 counts. We shall try and adumbrate them here. His lawyers were seeking to get bail for him today, but of course that has not happened, as you have seen. The General Court Martial head saying return on 28th, that is Tuesday next week, and then the bail application can be had. But of course there was a bit of some back and forth there. The lawyers of General Kayihura saying, look, you have previously allowed, verbal applications for bail, and that has worked elsewhere. Why not in this case? But Lieutenant General Andrew Guti there, the chairman of the General Court Martial, stuck to his gun saying, want this to be on record. So apply formally, and then on 28th of this month, next week on Tuesday, they'll get to hear that. And the trial itself is going to begin on 4th of September. That will be Tuesday the other week, not next week. And that's when everything will be playing out, as we shall be seeing how things happen. Of course, General Kayihura had hoped that he would get a sigh of relief today by being granted bail so he can get to be with his family. You had the passionate plea of one of his lawyers there, Counsel Eli Karuhanga, but that clearly fell on deaf ears. Let's talk to another counsel here, Counsel Galisonga, Julius Galisonga. Good morning.
Good morning.
You have followed what has happened. He's been charged with 3 counts. 1, failure to protect war material. Of course, the particulars of the case there. He allowed guns and other equipment to be used by Boda Boda 2010. The second charge, again, failure to protect war material. The particulars of that offense, he failed to provide accountability for equipment given under his care. And the third being that he aided junior officers to exile Ugandans to Rwanda.
And to deport Rwandese to Rwanda.
Come again?
And also to deport Rwandese refugees.
Oh yes. So there you are. So those are the 3 counts. Did you expect this? Anything different from what he's been charged with?
It could have been worse, probably with treason, because if you're failing to protect raw materials, if you're now working with foreign governments to deport refugees, it could have been worse. But well, at the end of the day, he's where he is. He's now being charged of those offenses. It remains to be seen how far the state can go with them.
I don't know whether this would be sub judice, but do you see the law at play, or is there a bit of politics?
I think from what has been read, at least there has been a long story towards each of these counts. We've read about the deported Rwandese, we've read about and we know about the misuse and conduct of Boda Boda 2010 with especially firearms. So you cannot say they are lying. At least for now, it plays with what is already in the public domain. the accusations against him, at least you can't say there is. Of course, at the end of the day, it is all politics, because it touches on how people exercise their powers, especially when they are serving government and when they're out of government.
Let's talk about the bail application that has failed at this level. What should be the modus operandi? Because there's a verbal process, and then there is when you go through the formalities, field documents, and so on. And you had the passionate plea of Counsel Eli Karuhanga, who was saying, look, you have previously allowed bail for others, verbally applied. You are saying no this time round. What's the modus operandi?
I think I would side more with Counsel, because when it comes to right to apply for bail, applications that are formal usually arise when a person is not in court. For example, he has not had the opportunity the first time he comes to court when he's being charged to apply for bail, or where he has been charged in a lower court. In the case, for example, these other MPs and others who are arrested with Bobi Wine in the north, in Arua, those ones generally, because they are charged in the magistrate's court, they can only apply in the High Court. But where you're applying, where you're appearing and taking a plea before a court which has jurisdiction to hear your case, you can do it informally. Because what the learned judge chairperson of the court martial said, that he wants a record. The most important record is not even what has been filed. The most important record is the court record, the notes they take down, because in as much as you file the application, at the end of the day you must support and present the people that we are talking about if it's sureties. So I think maybe you don't want to blame the court martial, but I think he was wrong. I think the lawyers were right to say that it can be done informally, because the Constitution says you have a right to apply for bail in whichever form.
The military has its interesting way of operating. For example, if you are a general and I am somebody of lower rank, I cannot arrest you, for example. They will send somebody who is similar rank or higher to take you in. We're having an interesting situation playing out here, because the chairman of the General Court Martial is a Lieutenant General, a rank lower than the person is trying, General Kayihura. Do you see any hiccup there, legally or otherwise?
I've looked through the Uganda People's Defense Forces Act, and I've not seen a mandatory requirement that a person who should hear your case should be a rank higher than you. It could be the practice, but at the end of the day, it is the competence of court to try a person that should be of more consideration. Because what happens where there is no competent senior officer to hear and to preside over the proceedings? So that has been the practice in arrest, but here we are talking about court proceedings. It would be akin to saying that a judge who was recently appointed cannot try senior counsel who has been recognized for being senior on the bench. At the end of the day, does that person presiding over have the competence to hear the case? In this case, I think that is the most important.
There's been lots of issues regarding the General Court Martial. People have raised certain aspects of it that are a bit problematic. Legally, of course, one, and we did see that in the case of General Robert Kyagulanyi Bobi Wine, that look, why should a civilian be tried before a military court, and yet it is possible for them to be tried in a civilian court? But also the other thing is that the folks that run this court, majority of them are non-lawyers. You know, if I'm not mistaken, the chairman of the General Court Martial is not a lawyer. And then several others that sit on that tribunal, prosecutors and so on. Does this not in any way make it difficult for justice to come through? Because if you're having people who are non-lawyers, who are meant to interpret the law, and who are leveling these accusations against you and so on and so forth, do we not see a problematic situation as far as delivering judgment, justice is concerned?
On that panel, since it's a tribunal, its processes are even more informal than the ordinary courts. But most importantly,
people and so on.
Most importantly,
to death even.
Most importantly, being a tribunal, they try to create conducive atmosphere for a person the chairperson, to carry out his duties. For example, you've been hearing about the judge advocate, there is the commissar. These are lawyers who guide the members of the tribunal on rules of evidence, how is admissibility of evidence, how to consider and weigh evidence. So for all over the world, you'd see that they create the necessary help that can help those people to preside over their proceedings.
Let me ask again, because the history of the court-martial is that it was established to check serving military officers, to discipline them when they get out of order, to bring them back on track. And I keep wondering, is it really because the ordinary courts cannot handle matters such as this? And I don't know how many other countries have a similar situation, but if there's probably not very many. Are we saying the civilian courts are incompetent? Because these guys are citizens too at the end of the day, and so when they commit offenses, one would imagine that a civilian court should be able to try them the same way they can try any other offense, capital or otherwise. Are we emasculating the civilian courts? Are we saying it is totally not possible for them to try such offenses? And so, because again there's continuous debate about the relevance of the general court-martial, its modus operandi and so on.
Section 118 of the Uganda People's Defense Forces Act defines the people who are subject to military law and who can appear before the military tribunal. That is the court-martial. Those people are not they are citizens in Uganda, but they are not your ordinary citizen. Why? They are subject to special rules that govern them. There are standards. For example, you, Joel, cannot be just ordered around, in as much as like an employee who is not a soldier does not perform his duties the same way as a police officer who are subjected to police tribunal, or a soldier who is subjected to the military law. Now, the reason why there is that tribunal or the military court is because for them they have the standard rules that governs them and the standard level of discipline that governs them, and they are judged within that standard. What would ordinarily pass off as a minor travesty on the part of an ordinary citizen may count so much in respect of a soldier. For example, you as an ordinary citizen can run away. Let us
pictures we're showing you, by those are earlier pictures. Several folks walking into the. Okay, there you are, General Kayihura earlier on entering the general court-martial, but anyway, keep submitting.
Yes, you, for example, in case of war, you have a right to run away in order to preserve yourself. As for a soldier, running away constitutes a crime.
My question, Council,
yes,
really was not about whether or not we don't have laws that provide for this.
Yes.
They are elaborately in place, but that there can be continuous discussion about this animal that we created called the court-martial. How sustainable is it? Because you see, if that be the case, in the civilian courts, several people can be tried therein. Abuse of office, for example, that if you're a government employee, there are certain expected responsibilities of you. If you don't execute them, you'll be held responsible, and maybe I might not be held responsible, and that kind of thing. And so we can have all manner of people tried, in the civilian courts. So why then does it have to be entirely different? Because again, if it is a soldier who should not run away in a case of war and should protect people, that the same way they can be tried there, that the same thing can happen in civilian court, and they say, by the way, you are duty bound to protect life and property. So when you run away, you are absconding from duty. When he runs away, he's running to safety.
One, you're calling them civilian courts or civil courts. So in essence, the first difference is the other one is a military court for the military and civilian courts for civil cases. Now, apart from that obvious difference, the most important difference between a military court and a civilian court is that this one is entirely dealing with a special kind of people. That is why today we have the labor court. At every district we have labor officers who hear labor disputes. If you're dissatisfied with that decision, then there is an appellate process. Now, even this military court is because of the special circumstances of the people who are subject to it that it is there. And most importantly, it is within the provisions of the Constitution that it is created. Because the standard you've been hearing, the lawyers saying a constitution, 48 hours, 1,000 something hours, it is all about, first of all, constitutionality. It is there, a creature of the Constitution, or created within the provisions of the Constitution. And then, most importantly, the nature of training these people undergo. Unless a judge is going to be part of that training, he may not be competent to appreciate the way they do business.
But I thought the 48-hour rule
to protect any kind of infringement on questions of criminal justice, there is an appellate process which can then allow other courts to look into what has been decided in order to see the justice of it.
Folks, again, I've been talking about the 48-hour rule because ultimately, whatever contravenes the Constitution is null and void to the extent of its contravention of the Constitution. So the 48-hour rule is embedded within our Constitution, and some will say, well, he's a military man, he understands, and so on. Earlier on in my prayer, I was talking about a group from Kisoro that went to petition the Prime Minister. They were saying, our son, release him, and so on, talk to the President, and he said, look, Kayihura knows what he did, so that will be handled. Does that mean then that certain things don't apply to them? And I know some people are happy that Kayihura spent, all this while in jail because he was pushing that when he arrests people, when he was IGP, let's keep them and that kind of thing. But you see, for me, I believe that justice, it actually makes a lot more sense when you push for justice for somebody you don't necessarily like, or even an enemy or that kind of thing. And so there are many people that will tell you Kayihura has done so much bad as IGP. Well, that's okay, and it is subject to debate. But be that as it may, the justice becomes real true justice, that even for a guy like this that you don't like,
everybody
deserves people in Kampala, Chiboko Squad and all these different things, that you say, okay, we want justice to prevail at the end of the day. So this does not apply in this case, you mean? 48-hour rule, as an example.
No, the 48-hour rule applies. It does apply. But you need to appreciate the background of Kayihura and the charges that are being brought against him. It also explains the nature of how even the lawyers were addressing court. Sometimes, like you've seen it, how lawyers tend to be aggressive when they are especially putting across questions of rights of their clients, but you see there is an element of discussion and trying to persuade, the element of persuasion. You need to appreciate that the charges against Kayihura are not the ordinary charges against any Tom Diko Hare. These are charges against a former IGP who took most of the instructions, though not directly related to these charges, but in the course of his work, took most of those instructions probably direct from the president. Now, as you are pushing charges against that person, there is a balancing act. How much damage can you do to yourself in the process of charging this person, or in the process of aggressively pursuing the rights of that person? How much good does it help? But the other thing that you need to consider is the 48 hours right, it applies, but at the end of the day, the unconstitutionality of it all can be remedied by an application by him for compensation for the infringement. But at least for now, he's in court, which is constitutional. Now that he's in court, which is constitutional, he can look into the rights of 48 hours. The High Court can go to look into whether or not his detention beyond 48 hours infringed his right, and how much can that be remedied? Is there a remedy? Can he be compensated for that? Probably yes. Can he be in any way placated? Possibly yes. And now, but for now, the consideration, and most important consideration, is that is in court.
Let's wrap it up this way, Council. Of course, there again is continuous debate about the trying of civilians in a military court. And tethered to this case, we did see the Border 2010 patron, Abdullah Chitata, and several others. Well, this ended yesterday, but Bobby Wine was being paraded in the military court, and eventually the military court said, all right, hands off. We can now hand over to the civilian process. Does it... Now that you've given a clear distinction, military court, try military serving folks who have gotten out of line, and then we have the civilian courts for civilians, but then other folks who keep arguing that, look, if the crimes you have committed or you are accused of committing are of a military nature, civilian or not, you should be tried in these civilian cases. What do you make of all this confusion?
It all comes back to the laws that we have. The laws that we have, and like we've seen in the social media, I saw you actively in that, opposing the social media tax.
Oh yes, and I still do.
Yes.
And not just social media, but mobile money tax.
Mobile money tax.
That one I'm on record.
It all comes back to the laws that we make and the people who make those laws for us. Why it is important when we are looking at the people we are sending to Parliament to make laws for us, because that is a principal duty of Parliament. Now, the law as it is that once a person brings himself within the ambit of the military, then he'll be subjected to military law. That is to say, if you're found in possession of military stores, or if you commit crimes that are of a military nature, then you'll be subjected to military law. Now, the only problem is it has now taken in people who are not necessarily supposed to be there, or it has even created room for blackmail where they just plant ammunition on you, then you're subjected to military law. Now, we need to ask ourselves, the people who are making these laws for us, are they competent? Are they in a position to foresee the bottlenecks that can come with making the laws that they are making? Until we do that, we shall always cry, but that is the law. Even if you went to court, to the constitutional court,
but that all right, it is the law. But
yes.
You know, the law is a living organism.
It is.
It can and should be able to change where need arises. Do you think it should change?
I believe it should change, but who will be able to move it? The court, even if it is interpreting that, even if you went to the constitutional court, I saw Maviri is petitioning the constitutional court to say that whether or not trying a civilian in a military court is constitutional. The question will be, not every civilian is taken to the military court. It is a civilian who does certain things, and once you do those certain things,
we must question whether or not it is constitutional. It can actually be in our law books, but does it have the constitutional element?
The constitutional element is fair trial. Unless you're demonstrating that you'll not get a fair trial before the military court, maybe. But if they are saying the military court is competent and you are allowed, the tenets of fair trial are provided for, you have right to counsel, they listen to your pleas, you're given time to put across your arguments, well, that is the fair trial. You see? But besides that point, and before you reach that point, you need to ask yourself, who are the people that we are taking to Parliament to make these laws for us? If the people who are being taken to Parliament to make these laws for us do not have the presence of mind to inquire into the laws that are being made, we shall be crying like you saw. No sooner had they passed the social media over the top services tax than people started quarreling. Even members of Parliament who are making noise to say, I didn't know. Now you ask yourself, if an MP doesn't know
what they passed,
yes, what they passed a few months ago, who should know?
Well, the president has told you severally, let's have many more of them from the NRM in Parliament. They can doze as long as they wake up and vote, and wake up and vote they did. Council Julius Galisonga, thank you for talking to us.
You're welcome.
All right, we'll take a quick break now. We'll get back to normal programming. We'll be bringing you events as they do unfold along the way. Good morning.
Turning on your world.
What would you define fashion as? It's not something you simply wear, nor is it anything you envision it to be.
Honestly, I feel like when I look at the bottom of this outfit, the skirt, it reminds me of the office trash can.
It's body perfection. It's the art that defines who you are.
These kind of wedding gowns tell so much about someone's personality. I would wear something like this, to be honest.
You?
Yeah, but literally with like a crop top inside.
When it comes to the red carpet, Step back, because we are here. You design it. You wear it. We critique it.